careful with
Yeah.
the economy. I don't know. Maybe two. I think it was, did a great job of confusing me. Working about 3 days a week, consulting full outfit. I'm working on doing this far enough to be Friday. I don't know if it's funded.
There's not a lot.
And then I got involved in yourself. Really, we're doing great stuff. Those that aren't here, I want to thank them as well. I believe next we have a roll call of the commissioners.
Yes. So the roll call for the May 1st, 2017 hearing. Commissioner Ager.
Here.
Commissioner Benton.
Here.
Commissioner Hawkins.
Here.
Commissioner Holton.
Here.
Commissioner Jolly.
Here.
Commissioner Randall.
Here.
Commissioner Wolk.
Here.
All present. We do have a quorum.
I'll entertain a motion for approval of the minutes or any changes that need to be made.
Move approval. Second.
All in favor, signify
Aye.
by saying aye.
Aye.
Opposed? Okay. I think next on the agenda item is a report from the Executive Director's Office.
Thank you, Commissioner Benton. Again, Bob Randall, Executive Director of the Department of Natural Resources. I'm going to spend my time this morning talking briefly, and I think Director Lepore is going to talk more about the incident that took place on April 17th in the Oak Meadows subdivision north of Firestone. This has been a topic in the news media, and it's a subject on which we've been working here. First, I just want to say on behalf of Governor Hickenlooper and the Department of Natural Resources, I want to express our deepest sympathies to the families of Mark Martinez and Joseph Irwin, who lost their lives in the explosion and the fire on April 17th. Our thoughts in particular are with Erin Martinez, who lost her husband and a brother, and who herself was gravely injured in the incident, and to her 2 young children. I also want to assure the public that we will continue to assist in the ongoing investigation in every way possible. That investigation is being led by the Frederick Firestone Fire Protection District, and we've been working with them. We appreciate the professionalism and the dedication of the first responders and the investigators, and we want to acknowledge the cooperation of Anadarko in the matter to date. Going forward, we'll also ensure that the Oil and Gas Commission has the resources it needs to continue its role in the ongoing investigation, to determine the circumstances associated with the tragedy, and to ensure public safety and the environment continue to be safeguarded going forward. So with that, again, I'm happy to take any questions from the commission. I'm happy to address other topics, but I did want to be sure that the commissioners were aware of our involvement in the ongoing investigation.
Thank you, Director. Any questions from the commissioners? All right, thank you very much. I believe next is Director Lepore.
Thank you, Commissioner. Good morning, everybody. I will fill in a little bit of the details of the actions that the staff, COGCC, has taken to assist Frederick Firestone FPD in their investigation. We are in an assist role, and I think everybody understands that that is an ongoing investigation. We held a press conference last Thursday. I know most of you are aware. I want to reiterate some of that information, however, just to make sure the commissioners are up to speed with what we've been doing. So with respect to the closest well to the 6312 Twilight Avenue, just a little history on that well. A lot of this has been covered in the papers and such, but it is a vertical well called the Coors V614JI, capital J, little I, that was drilled in 1993 by Garrity Oil and Gas Corporation. It is about 178 feet from that well to the southeast corner of the house and less than that to the property line. That well was drilled to the Codell Formation at a depth of 7,900 feet. It is primarily a gas well, although it does produce some oil. In 1997, the well was acquired by Patina Oil and Gas Corp. Patina recompleted the well to the J sand in 2001. The well was acquired by Noble Energy in 2005, and it was acquired by Anadarko in 2014. COGCC staff from our engineering group and our inspection group responded to the scene on Tuesday, April 18th. We have had someone at the scene every weekday since. We have been asked to provide technical support to the Frederick Firestone Fire Protection District, primarily on matters related to oil and gas operations and to potential environmental impacts. We have conducted some soil vapor sampling at 6312 Twilight in the house next door. Those were preliminary actions. We subsequently did a mobile methane monitoring survey with a vehicle-mounted methane detection apparatus. That mobile methane survey indicated that there is not fugitive emissions of methane in the neighborhood. We've also conducted a grid-based soil vapor survey, again, starting at 6312 and working outward. The results, preliminary results, and that is all we have from that, shown only very localized environmental impacts at 6312 and at one house to the west. No other soil vapor impacts beyond that. We do continue to believe that there is no immediate threat to surrounding homes, to neighborhoods, but we are going to continue with our environmental investigation in sort of the normal course as we would. I think that's all I have to say on Firestone incident. Other staff report items, I do, as usual, want to call your attention to the first couple of articles in the staff report. We're pleased that we have gotten to a place where we can will push notifications to LGDs of spacing orders in their jurisdictions. So this will be an automatic push notification to the LGD as a way to give them sort of an early heads up that an operator is interested in spacing lands in their jurisdiction. And usually what follows is pooling and spacing and wells and APDs. So just a way to kind of give them an early notice of pending activity. We've also made some important upgrades to the COGCC GIS online interactive map that we hope makes it easier for end users. Two specific features I wanted to call out. We are going to once again have the address search feature available, so citizens can type in an address and the map will take them to that address and they can look and see what kind of activity is happening around their address. And we are also adding county parcel information. So we live in this funny world where we speak in section, township, and range, and counties speak in parcels, and citizens think of street addresses. So doing our best to kind of make all those things available, and these are a couple of good steps forward in that direction. There seems to be some kind of epidemic sweeping the commission staff called leave-itis, I guess. I don't know, for lack of a better word. The latest victim is Britta Beckstead, who started here as an intern, I don't know, 4 years ago or so, thereabouts. My first year of being the director, Britta came to us through a fellowship from her law school. They paid her to work for us. It's a great deal, like others to follow that lead. We were able to bring her on full-time as staff. And then after not too long, she moved over to the AG's office, which was a great move for her. And now she is moving on to the Western Governors Association to pursue kind of her passion of policy and law. So thank you for being with us. Miss you, and good luck the rest of the way. I will touch briefly on the Martinez versus COGCC case. You all are aware, commissioners, that a group of citizens petitioned the commission for a rulemaking 3 years ago. The rulemaking had to do with not issuing any additional drilling permits until yourselves and a independent third body made a determination that fracking could be done 100% safely. You declined to take that rulemaking up for a variety of reasons. The citizens challenged your decision in district court. The district court upheld your decision, and the citizens took it to the Court of Appeals. And the Court of Appeals has reversed the district court, saying that in reaching your decision, you applied the wrong standard to your decision, and the Court of Appeals action would result in that petition for rulemaking coming back to you to reevaluate under the appropriate standard whether to take up the rulemaking. That decision can be appealed to the Supreme Court. The Supreme Court, you have to petition them to take an appeal. They don't take it automatically. So we need to make a decision about whether to take that action. And are we going to have executive session? Okay, so we'll have executive session to apprise you of the legal aspects of that choice. The Attorney General's office has asked for a continuance of the deadline, or an extension of the deadline to file the petition. The original deadline was May 4th. Has that been granted? Do you know? Okay, so we have gotten an extension until the 18th of May. Okay. That's all I have, Mr. Chairman, Acting Chairman, and I will take questions, of course, from the commissioners if there are any.
Thank you, Director. Any questions from any of the commissioners? All right, I believe next on the agenda, Mr. Gowan, is the commissioner comments.
Correct.
Any comments from any commissioners this morning? Thank you. Next is audience comments, and I think we usually have a list of folks. I think we normally do that sort of the speaker and a couple of on decks.
Mr. Chair, it looks like we have 5 people signed up, and we'll call them, but want to call people's attention. We have a timing device at this point. Public comment is limited to 3 minutes. This device will show a green light starting with your comments at with 30 seconds left. You'll see an amber light. When your time is up, it'll turn red. And each time the light changes color, you'll hear a short beep. So we do ask that you try and restrict your comments to the allotted time. Thank you. So first up is Jennifer Gamble. Next up is Cheryl. Okay.
We're just going to come up together because we're sort of tag teaming here.
Yes.
Good morning. My name is Jennifer Gamble, and I am the president of Adams County Communities for Drilling Accountability Now. Our statement is regarding concerns highlighted by the Firestone home explosion. Information formally released by Anadarko, COGCC, and the local fire department regarding the home explosion at 6312 Twilight Avenue and the possible causal link to the nearby oil and gas well and/or gathering lines highlight the need for certain actions. The following actions are needed regardless of whether or not the explosion at the Martinez home is ultimately tied to existing oil and gas. The fact that both COGCC and Anadarko believed that it was a strong enough possibility to take the actions that they did shows that there is probable potential risk to homeowners caused by proximity to existing wells and gathering lines. Number 1, setbacks are needed for existing wells. The possibility that an existing vertical well 178 feet from the home or its associated gathering lines may have played a role in this explosion highlights the need for safe setbacks of new construction proximate to existing wells or gathering lines. These must be established and consistently enforced statewide, either by COGCC or legislated by the state legislature if COGCC continues to abdicate that responsibility to local governments. Local governments do not have the knowledge, expertise, or resources to determine and set safe setbacks. It is COGCC's responsibility to protect the public health, safety, and environment in the realm of oil and gas. Number 2, location mapping and regulation of gathering lines. Currently, there are no regulations regarding development over or near existing oil and gas gathering lines. In some cases, the locations of such lines are not known, mapped, or identified. As development encroaches on established oil and gas, these lines can and will likely be disturbed and may result in future accident, injury, and death. Therefore, COGCC should enact rules requiring these existing lines to be located, identified, and mapped, and to put in place regulations that are protective. If COGCC abdicates this responsibility, the state legislature should step in to fill this void. Cheryl?
In addition to those two comments, good morning, first of all. We also, yes, I'm Cheryl Tadlock. I am also a member of the board of ACTDOwn, the organization that Jennifer's president of. So in addition to those 2 points, we would like to add that there needs to be increased inspection frequency and or closure of these older wells. Obviously, as oil and gas infrastructure ages, more incidents, spills, and possibly accidents are likely to occur. The well near the Martinez home had not been inspected since 2014. That seems to be inappropriate. COGCC must ensure that all wells are inspected on at least an annual basis, in particular older wells, obviously, for the risks that are associated. We know that older wells are more likely to have leaking and other issues, and because of that correlation, there should be more frequent inspection and regulation. Also, pressure testing should be required. And if not actively producing and being monitored monthly by operators or inspected by COGCC, those wells should be closed and remediated to reduce associated risks. These actions should obviously be accelerated if the explosion at the Martinez home is found to be related or tied to that 1993 well or gathering lines. Obviously, we know that's not known yet, but if they are found to be related, then there needs to be more frequent inspection and monitoring and complete closure and remediation. Our last point, timeliness and transparency in public information. The COGCC stated that it had been involved in the investigation of that explosion since April 18th. And then subsequently, Anadarko began shutting down its wells soon after the explosion. But neighbors and the public were not informed of the activity until over a week later. That appears to be an issue. It's not acceptable in terms of transparency in government, and especially where matters of public health are involved, to wait that length of time, especially if things are not known. The public had the right to know that there was a potential danger, that nearby oil and gas wells and or gathering lines could have been a hazard to them, so that they could each elect to take their own protective measures, such as staying in a hotel or relocating temporarily, until the danger is fully investigated and concluded whether or not it still exists. Obviously, like I say.
Well, since there's two of you, we'll give them 6 minutes total.
Thank you.
Okay.
Thank you for that.
We applaud Anadarko for the cautionary measures they took to protect but those measures should have been announced sooner. In addition, final point, COGCC stated that methane tests after the wells were shut down.
Go ahead. Just keep going.
You guys stated that methane tests have found no leakage, no remaining methane. However, were there tests done before the wells were shut down? When was the last test done? And did those tests indicate the presence of raw natural gas with or without additives so that it could be actually known? Just in general, as far as testing goes, we are disappointed in the timeliness and transparency of information.
Thank you.
Thank you for very clear, concise, and well-prepared comments.
Okay, next up, Christine Nicolou and Nanner Fisher. Go ahead.
Thank you for allowing public comments, first of all.
You're welcome. And we would ask, please state your name.
My name is Christine Nyholm, and I live in Brighton. I'm a board member of ACTAN. I'm a mother and a grandmother, and mine is mostly an emotional plea, honestly. I cringe. Actually, I get angry every time I see that cred ad on TV that shows a pristine environment and touts how Colorado has the best oil and gas regulations in the nation. Coloradoans, I think, are being blatantly misled with that ad. I think what the cred ad doesn't say is that we all must be concerned about is that, and everyone here knows that there are hundreds and hundreds of wells coming our way. I mean, the big oil and gas pads. And they're going to affect thousands of families like the Martinez family. You all know better than anyone that it is impossible to inspect these wells in a regular, timely manner. In fact, I remember Director Lepore, you mentioned that at the Adams County study session we had when we were talking about wells coming into neighborhoods there. But there is an even more insidious danger, the hidden pipelines that will soon be flowing with hundreds of thousands of gallons of oil and gas right next to our neighborhoods and under our homes. These pipelines must be regulated. Housing developers must be aware of where they are located, and it must be disclosed to homeowners before they purchase their homes. Like the Martinez home, where they hope to raise their 2 children and now don't have a father, and their mother is critically injured. What does it take? I'm just begging. I'm saying, please, please, to both our commissioners and to the oil and gas industry, promulgate regulations for greater well pad setbacks and much greater transparency of pipeline locations before anyone else loses a loved one. Thank you.
Thank you very much.
Next up, Nanner Fisher, followed by Lauren Swain, I believe.
Hi. My name is Nanner Fisher. I live at 12476 Niwot Road in Colorado, in Longmont. Our property is in the 12 square miles that apparently a lot of the companies are here fighting over today for permitting. And I'm here to say that I don't think any of them have any rights to any permits anywhere in the state, let alone in my 12 square miles, until the COGCC can prove via updated written regulations that they are adhering to the Colorado state statute that was just created on March 23rd as a result of the Youth versus Colorado oil and gas case that Director Lepore talked about earlier. On the 23rd, as he said, in a 2-to-1 decision, the Colorado Court of Appeals found that the COGCC erred in its interpretation of Colorado law, stating, and I quote, "We therefore conclude that the commission erred in interpreting the Oil and Gas Conservation Act as requiring a balance between development and public health, safety, and welfare. They determined, and again I quote, the clear language of the act mandates that the development of oil and gas in Colorado be regulated subject to the protection of public health, safety, and welfare, including the protection of the environment and wildlife resources. As of last night, when I searched the COGCC website, I could not find any indication that the COGCC had developed, let alone began any implementation of any new set of regulations that prove the protection of public health and safety are now the sole priority in the permitting process. In fact, there was not even any mention of the case, the statute, or a statement of pending changes. It still says you are there to serve all of those who have an interest in Colorado's oil and gas natural resources. I'm presuming all still includes developers. And until that is changed, no permits should be issued, period. Why is that? Why is there even a thought of an appeal? Why would you not want to solely protect the people? What's it going to take to make the COGCC adhere to the new statute? Do people have to die? Wait, people are dying. We just lost people in Frederick. The cause is likely of the well within 175 feet because of your setback loophole. Why would you create loopholes to protect the industry and not the people? If the COGCC ever needed a wake-up call, this should be it. No more lives can be endangered so that big business can prosper, and that's no longer just my opinion, it's the law. And if the commission refuses to comply, a private investigation or lawsuit is surely pending. Thank you.
Thank you, ma'am.
Next up, Laura Swain, followed by Wes Wilson.
Hello, I'm Lauren Swain. I live at 3277 Raleigh Street in Denver. I've been working on oil and gas issues, trying to bring logic and a sense of protection of people's health and safety first to Colorado policy for the last 5 years. And I wish that our government agencies were doing this job for me, which they're supposed to do. And the Martinez ruling has shown that they have been charged from the beginning and ignoring their charge to prioritize public health and safety and the environment over their other mission to foster drilling for this entire time. And up until now, they have been failing and misinterpreting their mission and putting oil and gas development first. That is unacceptable. Why? Because spills, fires, explosions, toxic emission, ozone pollution, and water contamination are ongoing, frequent hazards of drilling activity, and no other industry is allowed to do these close to our homes without regard to local control. That's an abomination. How many here feel that it's an abomination? Thank you. So, to follow the Martinez ruling, you have to put health, safety, and the environment first over drilling. And since we seem to not have things straight about the risks that we're all subject to, and this fire, this explosion in Firestone is but one of many, many symptoms of that. You know, there are hundreds of spills every single year, close to homes, contaminating water. And many of these facilities require air pollution permits that are granted when we're already failing in air pollution standards in this state. That's unacceptable. How many people would like to see no more permits issued by this agency, at least until they get their act together and protect us? How many people would like no more wells permitted? Can I hear from you?
No more wells! 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 Mr. Chairman, this is not a circus.
This is, excuse me, I'll get back to my message here. I cannot believe that I'm staring at people who pretend to be human beings, who pretend to represent our interests, who are considering appealing a decision to prioritize our health and our safety. And they're going to do it in private. Why? I would do it in private too if I was going to do something as appalling as that. How dare you even contemplate not prioritizing our health and safety? You should not permit another single well until you figure out how to do that. Thank you.
Thank you.
Next up, Wes Wilson, followed by Cliff Wellming.
Thank you. My name is Wes Wilson. I reside at 25058 Street here in Denver, and formerly an engineer with the Environmental Protection Agency. On behalf of Be the Change and other nonprofit organizations, we're going to shortly call for an independent investigation into the Firestone incident. Look at the facts before you. This explosion occurred on April 17th, but it wasn't until a week later that the public knew that there may be a possible association with a nearby vertically drilled well, leaving in that time them to speculate perhaps on some other cause. Well, it might have been from the city gas line by this professional plumber. Some 33 years ago in LaSalle, Colorado, an explosion took place at a lumber yard which had fugitive gas emitting from a nearby abandoned water well. In those 33 years, we don't know what caused that explosion. Fortunately, in that incident, no one was hurt. 33 years, we don't know what happened in that explosion. We're not going to wait another 33 years. We need an independent investigation. Firestone is made up of, its fire department, is good people, is mostly made up of volunteers, which lack the experience in the oil and gas industry. And while the commission and the staff have experience, the public doesn't have trust. This is a commission that reported that there was no effect from the floods in 2013 on the oil and gas industry because it had to accept the word of the industry. This is a commission who did not require Anadarko or Great Western to shut in wells. They were doing it on their own. We need an independent investigation. I think you can see why. We have the academic institutions here in Colorado to perform that and hold public hearings. One of the interesting geologic questions about this possible explosion was raised indirectly by Commissioner Holton. He recognized, I think as you recognize, that new frac wells could connect to the higher J Sands vertical wells. Now, I have no idea if that's the proximate cause. Could be a feeder line, could be the well. We demand a public investigation with transparency so we can put this matter to rest. Thank you.
Thank you.
Next up, Cliff Wellming, followed by Phil Doe.
Hi, my name is Cliff Wellming. I'm from Lafayette, Colorado, one of the communities that was sued by the Colorado Oil and Gas Association to force oil and gas activity into our community against the will of the democratic vote of Lafayette community members. I'm here as a father of two. I'm here as a registered nurse, and I'm here in an official capacity from the Boulder County Protectors, who are now looking at upwards of 2,000 wells being forced upon Boulder County, again, against our will. I'm not here to make a plea to this body. After extensive review in Boulder County, we have determined that this body does not have any legal representation or authority over the health, welfare, and safety of the lives of the people of Colorado and of Boulder County. We are here to say that upon recognition that this body claims to represent people when in fact it has no civil rights or legal authority to do so, we have done an extensive review of the permitting process in Boulder County, and we have concluded that all permits will be denied by the people of Boulder County. I have to say this as a father. as a registered nurse and as a Boulder County protector, we will not be allowing a single well into Boulder County. So you can please let Crestone know. I hope there are representatives of Crestone here. I hope there are representatives of Extraction here. We do not recognize the authority of this body, and we do not recognize the authority of those industries to override the free people of Boulder County and to override our health, welfare, and safety, to destroy the climate, to destroy the environment, and to siphon not only material wealth out of our state, but all of the profits that are included within that. So thank you very much.
Next up, Phil Doe, followed by Christy Douglas.
Good morning. My name is Phil Doe. I'm the environmental director for Be the Change. As Wes reminded you, we're seeking an independent investigation of the Firestone incident. Let me give you some background as to why we think this is necessary. I was in the courtroom when Jake Matter told the judges that your interpretation of the law was, you apparently don't understand subordination in the English language, that you could only protect the public health and welfare 50% of the time. The other 50% of the time you had to encourage oil and gas, when in fact the sentence says that you must protect human health and welfare. And you can only develop oil and gas when it's consistent with that thought. How you came up with 50-50, which amounts to the fact that you can't protect the human health and welfare, is beyond me, or the environment. I think you need a moratorium, no matter what we do, and no matter what our appeal is to the public. For the simple reason that your rules are blind to what goes on in the field, as the Firestone incident clearly demonstrates. You have a 500 and 1,000 foot setback, which the commission recognizes as having no scientific basis. It's simply a moving target that you all implement every time the public becomes outraged over what's going on in their backyards. But even if the 500 and 1,000 foot setbacks are to have any meaning, they have to apply to all. They can't just apply to the oil and gas industry. They have to apply to the developers. They have to apply to the county planning commissions. They have to apply to the city planning commissions. Otherwise, it's a joke. And these people understand that this is a joke. They're threatened every day by a system that simply does not work. It works for the oil and gas industry. It's blind to what's actually going on in the field, and it has to change. I mean, you have an explosive situation out in the field, and there are people in this room that are responsible for that. It is obviously not safe, Dr. Walk. Obviously, it is not safe. That claim cannot no longer be made. So what are you going to do about it? That is the question you must answer. And I would advise you not to go into private session on this. The public is vitally interested. It's a public interest issue. It is not a private legal issue. It is a public issue. And to hide from the public on this issue, I think is absolutely, you're defaming yourselves. I'm sorry, but that's the way I feel. Thank you.
Thank you very much.
Good morning. I guess you're bored. My name is Christy Douglas, and I reside in Commerce City. I've been fighting this fight for 6.5 years when Mr. Lepore was then the attorney for the first fracking well that came in the middle of the night in Commerce City, right behind a neighborhood and a Starbucks. We didn't know what it was until we asked for an entire week, and I found out that Friday morning when I discovered by searching the internet that the site was identical to a Chesapeake drilling site that I found on the internet. We were told that we could not protest, that we could not go over there to voice our opinions because we would be trespassing and we would be arrested. Intimidation has not gotten me down over the last 6.5 years, and I refuse to go away. by my button, I am not a paid protester. I'm an organized protester. So I want you to know the reason that I continue to do this is that there are too many unknowns. We don't know the dangers until it's too late, as evidenced by this fatal home explosion where 2 men lost their lives while working. They were working on a water heater, and then the wife who was with them, she's in critical condition. What if that was one of your family members? Would you be sitting up here now? I want to read a little bit to show you why we should not be burdened with the risk of the unknowns. And this is out of the article from the Daily Camera. 2 orphaned wells in Mesa County were leaking so much gas and water in 2011 that a landowner told state regulators he could see it bubbling up from the ground. Investigators who dug down found the entire casing of one of the wells had either been removed by the former operators or corroded away entirely. And Christine, when you said you were up here with emotion, with an emotional plea, I can certainly understand. I have gone broke trying to fight this industry. That's just one of the examples right here in this article. But I hear that my time is up. What I'd like to conclude with is a statement off a Facebook site that I found. Oil and gas, we're going to go ahead and turn your town into an oil field. We understand this will compromise everything from your property values to the health of your children, but we expect you to be quiet, cooperative, and respectful while we do. Your elected officials will assist you to find the appropriate tone and venue for your objectives while we bring in the rigs. I want you to know that I believe America is simply an oil and gas company with an army. Unknown Facebook post. Thank you.
Thank you for your time.
Next up, Michelle Hernandez Goodwin.
For the record, it's Godwin.
Sorry.
I'm here spontaneously. I'm upset about what happened in Firestone, and I know that it was not the first time a home has exploded. This happened in Trinidad in 2007. A man nearly lost his life. What if next time it's a school? You are allowing thousands of wells to go in, and nobody knows what is going to be the ultimate result and dangers posed by those wells. They are supposedly closed by concrete. Anyone with common sense knows that those pipelines and that concrete is going to deteriorate over time underground. We have potentially thousands of ticking time bombs going in by our schools and our homes and under our homes. Why are you allowing this? Why are you putting my children at risk and your own? What is oil and gas going to do about it? Nothing. They make their millions and then they take off. How much is it going to cost us to monitor and check and see if methane is leaking into thousands of homes from thousands of wells? We got to pay for this? The taxpayers have to pay for this? As oil and gas takes off with their millions? It's insane. When is reason and foresight and compassion going to come back into play here? Instead of a focus on so-called progress and greed. I've had enough. Figure this out before you allow more wells and more ticking time bombs to go off under another person's home. And don't tell me it had nothing to do with oil and gas. This isn't the first time, and it's not the last. And the blood will be on your hands.
Thank you.
Mr. Chair, that concludes those who have signed up.
Is there, certainly we have some time. If there's anyone else that would like to speak, even though you haven't signed up. Thank you, ma'am.
Yeah,
May
that
we
is
have
a-
your name, please?
Sure. My name is Lauren Petrie. I live here in Denver, but I'm the Rocky Mountain Region Director for Food and Water Watch. I want to thank all of the residents here for speaking up passionately about this dangerous situation that we find ourselves in. It is absolutely reprehensible that the commission spent 3 minutes addressing the tragic explosion in Firestone and offering their condolences to the families that lost loved ones. Yet you're going to spend the bulk of the meeting talking about allowing over 500 brand new wells in Adams County. How is the COGCC going to...
Just a moment, don't mean to interrupt. I'd like to please have the audience allow the person to speak. Those of you that spoke earlier, please remain quiet so that we can hear what the speaker has to say. Thank you.
So how is the COGCC going to prevent another tragedy like the one that just happened? The answer is you can't, obviously, because you couldn't prevent this one. And Matt Lepore, you recently stated in an interview that there is no set of regulations that will get the oil and gas industry to 0 accidents. Clearly, this can't be done safely. You can't guarantee the safety of people when you're drilling 100 feet from their homes or the 800 feet from their schools. You can't guarantee it. You also stated that you don't live near oil and gas development, but you understand why other people don't want to. Do you understand now why other people don't want to live near oil and gas development, especially when they don't want it there to begin with? There are over 55,000 active wells in Colorado, not counting the 30,000 plus that are abandoned and probably leaking somewhere, and you're smirking, which is kind of disgusting. All of these wells, there's no follow-up inspection. All of the wells, new and old, active or abandoned, the infrastructure from the pipelines to the gathering lines or explosions waiting to happen. And the COGC is putting lives at risk every single day as you blindly permit these ticking time bombs in our backyards, in our children's playgrounds and schoolyards. It's time for the COGCC to prioritize public health and safety. According to the Colorado Court of Appeals, it's your job to put our health and our safety first, not the industry's profits. Thank you.
Thank you, ma'am. Is there,
Yes, my name is Barbara Millsbury. I live in Lakewood, Colorado, and it's my understanding that there is a loophole that you guys are, I guess, supporting. There's no inspections of pipelines. Is that correct? Are there any rules or regulations concerning pipelines? Well, I guess you are reluctant to even say that out loud, but apparently that is the case. So that's another loophole that needs to be considered. Thank you.
thank you, ma'am. I'm not sure, Director, if that's a question we would want to address at this point.
COGCC has jurisdiction over flow lines, and there are gathering lines and interstate pipelines regulated under different regimes.
Thank you. Is there anyone else who'd like to come forward? I think we have another individual.
My name is Vivian Weinstein. I'm a resident, lived in Colorado Springs for 3 years, came here, and I've been here for 3 years. I came to hear this because I read the articles and my breath was taken away. And then the first person I couldn't quite see who got up to speak to describe the incident. You called it an incident. It was an explosion. Nobody says explosion. They say incident. I mean, my kids, dropped a glass and spilled some milk. That's an incident. When 2 lives are lost, that's a lot more than an incident. And this has happened before. I came from Maryland before I moved here. And at the time, there was no fracking, but they wanted to build from Pennsylvania, they wanted to build the storage tanks and the pressure stations and in Maryland, and they got the law so they could export gas now instead of just for our own energy independence, which is a big lie. So now they could export. So they needed a place to export it in the east, and Maryland was great. It was right on this gorgeous Chesapeake Bay. They were going to build a 60-foot wall and put in all these storage tanks and everything. And near there was a battle because some of these pressurizing stations for the gas might be near schools, etc. And so a big meeting was called, and hundreds of people showed up. Really, and I didn't know hardly a thing about oil and gas at the time. And I even thought gas was really good, better than oil, and no idea about fracking, which I do now. And the people, this environmentalist got up and he said, I used the company's figures, and according to the oil company's figures, the environmental effect, just the environmental effect on Maryland, this little state of Maryland, with these pressure stations and the storage tanks and the leaking, et cetera, would be worse than the 6 coal-fired power plants that we already have. And that just turned me around. And I started to read and understand quite a bit more about fracking. I mean, I've spoken to drillers, I've spoken to workers. Okay, it's the most dangerous industry. It really is in this country. There's high rate of death, injury, and that's just to the workers. Not even the community. And nobody wants to talk about this here. But I will say one thing, that after a temporary moratorium in Maryland, okay, just on putting these tanks into the state, and a possibility of fracking in the state, for 2 years they had a moratorium, and they finally came to the conclusion, like New York State, and they banned fracking. That was the scientific conclusion for the safety of the people in that state. I'm just hinting at what you might need to do here.
Thank you for your comment. There's no one else. I think we have one more. Oh, thank you. Yeah, I think these are all individuals that did not sign up, correct?
That is correct.
Okay. Unless there's anyone else who has an urgent desire to speak, we are going out of time.
I was told I don't sign up.
Okay, then we'll let you speak too. Thank you.
Thank you, Mr. Chairman and committee. My name is Stuart Nyholm. I'm a resident of Adams County. There's a lot of emotional issues here, and we're hearing about that, and certainly we're concerned. But the thing I'm curious about is, again, dovetailing off of Mr. Lepore's comment, if we don't have responsibility, who does have responsibility for the gathering lines? And that's where it seems like it's the hole in the regulations, that we don't have control over the gathering lines or the flow lines. If it's another agency, how do we put pressure upon those agencies to do their job to check out what's happening? Does it rely upon the counties? Do the counties have some input in this process? But I would ask that you begin to take a look at that issue to see what you can do under your regulations to take more responsibility for what happens with the gathering lines and the flow lines that are on our homes and our properties. Thank you very much.
Thank you very much. Sorry, come on ahead. Sorry.
Hello, my name is Nusheen. I'm a resident of Westminster. I assume that most of you are fellow Colorado residents. Some of you may not be. The facts speak clear. The scientific facts speak for themselves. The toxins that are entered into our soil, into our water, the earthquake risks, contamination, the off-gassing, the leaking, we know all that. We don't need to go over all that. The explosion we just had, we know that 40% of the wells are leaking as we speak. So all that is clear. But I assume some of you may have kids, or you may have family who has kids. Just go to a family physician and ask them how the incidence of allergy-like symptoms have increased. I did that for my son. My son plays soccer, and he was having a heck of a time breathing during soccer. So I thought, well, maybe this is sports-induced asthma. I took him into our physician and said, no, this is not asthma. These are asthma-like symptoms related to all the added air pollutants that we are experiencing in our area in the Front Range. If you have any doubts about it, please look up the science. The science is there. University of Colorado, Ann Schultz has done a research on this. So again, don't do it for, it's not an us against you type of a thing. All of us are in this together. Please protect our water, our soil, the health of our kids. Our kids don't have a way to protect themselves. So if they get bullied at school, or if anything is happening to them to damage them, we speak up for them, or we try to advocate for them. This is the same thing. Please advocate for your kids. Thank you.
Thank you, ma'am.
So my name is Tom Fisher.
I'm sorry, could you repeat that, please? Again?
Tom Fisher.
Tom Fisher, thank you.
So after all you've heard this morning, you're still going to spend the next 2 days determining what permits you will issue. No more permits. Show us you're listening. Cancel the hearings.
Anyone else? All right. Thank you all for the comments. We appreciate that, and for taking your time to come down here and speak. We appreciate that as well.
I would like to say one more thing. I said that I've gone broke doing this, but I want you to know that all of us here are working people. We took time off of work. I stayed up until 2:30 in the morning last night. I got up at 6 so I could rearrange my day so that I could be here, so that you could hear our voices. Do not ignore us. Do not ignore us.
All right, thank you.
No more wells! No more wells!
Okay, we do not need this.
No more wells.
We're going to take a brief recess so that the folks that were here for the public comment period can, I believe they said they took time off from work and go back to work. We'll reconvene about 10 after 10. believe, Mr. Gowan, we now have everyone.
Yes, we can proceed. The
So we
next
can
item
proceed.
would be the consent agenda.
All right, and I think we need to ask as part of the consent agenda if there are any potential conflicts of interest and anyone needs to recuse themselves or make any adjustments to the consent agenda. Hearing none, certainly would entertain a motion.
I move we approve the consent agenda.
Second. And that would be, for clarification, consent agenda items A through U.
Items A through U.
All right. Moved and seconded. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Next on the item, we have an enforcement group on the consent agenda. Any items that any individuals need to recuse themselves or make any adjustments to the enforcement agenda? Hearing none.
Mr. Chair, I move passage of the enforcement agenda.
Is there a second?
Second.
Motion made and seconded. All in favor signify by saying aye.
Aye.
Aye. Motion carries. Thank you very much. Mr. Gowan, what's next?
Next matter is actually moved up. It was originally scheduled for, I believe, 5 o'clock, but it is docket number 170300116. It's the applicant is Noble, and hearing officer James Rouse will explain the setup for this matter.
Good morning, Commissioners. My name's Jim Rouse. I'm the hearing officer assigned to this matter. This was an application filed by Noble Energy to create an approximate 2,560-acre drilling and spacing unit and approve up to 26 horizontal wells for the unit for the Cordell and Niobrara formations. Originally, it was protested by PDC Energy, but Friday afternoon, this matter was settled. We have no 511 testimony in the file because of the existing protest. And so we were unable to place it on the consent agenda, and Noble will be presenting their prima facie case as to why they should have a spacing application approved.
Good morning, everyone.
Morning.
Thank you. You just let me know when you'd like us to proceed.
Please proceed, Counselor.
Excellent, thank you. My name is Jamie Jost from Jost Energy Law, here on behalf of Noble Energy, Inc. We are here in docket number 17, not first things first, 1703-116, which is now an uncontested matter. My apologies, let me get this up. As Mr. Rouse said, this matter settled late Friday afternoon. PDC had protested this matter and voluntarily withdrew its protest late in the day. So we're here to have a very, I would say probably a pretty quick presentation for purposes of our witnesses. We do have a land witness, a geologic witness, and an engineering witness. So we didn't know if you wanted to go ahead and swear them in or if you'd like to do that one at a time.
Why don't we do them all at one time? Let's do it now.
Thank you. Okay, Brian, and then we have Heather and Scott. If you guys want to go ahead and come up.
You can just stand where you are. That's fine.
Sure. Okay.
Do you swear, raise your right hand, do you swear or affirm under penalty of perjury that the testimony you'll provide in this matter is truthful and accurate? Thank you.
Thank you. Great. This application is a very straightforward drilling and spacing unit application. It was filed on January 19th, 2017. It was continued from the March hearing because we did have this as a protested matter. The request in the application is to approve a 2,560-acre drilling and spacing unit, and this is for sections 31, 32, 33, and 34 in Township 5 North, Range 66 West. Noble owns approximately 70% interest in the unit, and as it stands, we now remain unprotested for the remaining 30%. The request asks for up to 26 new horizontal wells in the unit to efficiently and effectively develop the hydrocarbons underlying the unit for purposes of the Codell and Niobrara formations. The application has requested 460-foot setbacks from the unit boundaries. This is within the greater Wattenberg area, and so those are the standard setbacks within the area. 150-foot interwell setbacks, those subsurface setbacks, and 4 well pads, and unless an exception is granted by the director. At this point in time, Noble has filed its applications for permits to drill, as well as the Form 2As for the wells within this proposed unit. These applications and Form 2As are currently in process and are pending approval based upon the outcome of the spacing hearing today. It's my understanding that the comment period for the APDs and the Form 2As has closed. There was no extension requested by the Weld County LGD, and no protests have been received. This is not an issue where we have a competing drilling and spacing unit application or any wellbore spacing units within the matter. This is a very straight drilling and spacing unit request. So what we would like to do is request approval of this unit after you hear the testimony from our witnesses. And if you do have any questions for our witnesses as we're walking through, please feel free to address them. So I am going to go ahead and introduce, this is Brian Bolton, and he's a senior landman for Noble Energy, and he's going to walk us through the land exhibits. So Brian, could you please just provide the commissioners with a brief overview of your role at Noble and your familiarity with the land?
Good morning. My name is Brian Bolton, and I'm a landman with Noble Energy. I've been working on this part of our Greeley Crescent IDP for the last year and a half with our development plans and this DSU as it moves forward. We are Noble in the 2560 spacing unit is an approximate owner of 70% of the working interest, with PDC and extraction and various other smaller working interest owners owning the remaining 30%. There is no unleased interest in the DSU, and both the minerals and the surface are held in fee. And sorry. So here are Exhibit 1 with our leasehold ownership, showing Noble in solid yellow and the hatch yellow and white, where we don't own a full 100% working interest, and then 0 working interest in Section 32.
Brian, can you just please explain Exhibit 2 and 4 up here?
Exhibit 2 is the mineral ownership. All 4 sections are held in fee. And then Exhibit 4 is the surface ownership, and all 4 sections are held in fee as well.
Great, thank you. And can you please walk us through Exhibit 3?
Exhibit 3 is our property location plat with our proposed sticks that we've submitted applications for permit to drill, with 460-foot setbacks and 150 feet between the proposed wellbores.
Excellent, thank you very much. Are there any questions for Mr. Bolton? Okay, yes, Mr. Hawkins.
Just taking a look at your exhibit and the location of the wells. And so these wells, they're all located on lands that Noble has working interest in.
Right.
And you only see 3 locations, but I know you're asking for 4. Is that just a potential 4th in the future?
Potential 4th in the future based on the engineering needs that we could be foreseen just as we move forward in the process.
Thank you.
And for confirmation, the surface locations are also covered by a surface use agreement that allows for more locations as well.
Great, that was my next
Yeah.
thought. Thank you.
Thank you. All right, thank you, Brian.
I'm sorry, but that you're not allowed to answer questions from the audience. We're in a hearing. Thank you. And I've been reminded by our attorney that this is an unopposed application with no protest.
Thank you. So I'm going to introduce Dr. Heather LaRue, and she is going to walk us through the geology exhibits that we've submitted in support of this application. So Heather, could you please provide the commissioners with a brief overview of your role at Noble and your familiarity with the application lands?
Absolutely.
Thank you.
Dr. Heather LaRue, I've been at Noble for 4 years and in the industry for over 10, and working on this project as a technical and development geologist since it was started. So familiar with the lands under consideration in this application.
Great, thank you. And can you please walk us through your Exhibit 10? And just for purposes of clarification, these exhibits do not go 1 through 17 in order for this presentation because PDC withdrew their protest so late in the day on Friday. We thought it might be more consistent to utilize the final exhibit numbers that were sent in last week for purposes of final exhibits. So you will see an inconsistency in the numbers, but they're the ones we're utilizing for support. Okay. All right, thank you. Can you please walk us through Exhibit 10?
Absolutely. So what you see on the screen right here is a structural contour map that's located at the very top of the Niobrara Formation, and it's in TVD-SS, so total vertical depth subseas.
Great, thank you. And can you please explain Exhibit 11?
Absolutely. So Exhibit 11 is actually an isopack or a thickness map of the Codell Formation, and you'll notice that it's between 19 and 20 feet in this area under the lands.
Great, thank you. Can you please explain Exhibit 12?
Very similar to the previous one. However, this is now the Niobrara, which overlies the Codell. And it is a thickness map that's showing a range of 272 to about 2,600 feet thick.
Great, thank you. And can you please explain Exhibit 13?
Absolutely. On the previous slide, I should have mentioned there was a line that showed the line of section from west to east. So this is a cross section. So we're looking at the vertical cross section view of lands underneath in the application, and it includes the Niobrara and the Codell from top to bottom.
Great, thank you. And can you please walk us through Exhibit 14?
Absolutely. This is a close-up of a type lag, so very characteristic of the geology and the petrophysics in the area. And again, it's showing the Niobrara down through the bottom of the Codell, and it has all of our petrophysical electric logs on there showing resistivity, porosity, and gamma ray.
Great, thank you. And is it your conclusion that the Codell and the Niobrara Formation underlay the application lands?
They do, absolutely.
Thank you. Are there any questions? All right, thank you very much. Thank you. Great. All right, so for our last witness, we have Mr. Scott McIntyre, who is a reservoir engineer, I believe, from Noble Energy. And Mr. McIntyre, can you please provide the commissioners with a brief overview of your role at Noble and your experience with the application lands?
Yes. Good. Nice meeting you today. My name is Scott McIntyre. I'm the development lead for this development area. I've directly supervised and contributed to all these materials that we're looking at today through our team at Noble Energy. I've been at Noble Energy for about 6 years so far, working on the Niobrara development.
Great, thank you. And we're going to do the same thing. Can you please just explain Exhibit 15 to the commission?
Absolutely. The purpose of this exhibit is to show our current best understanding of how the wells actually drain the areas that we're talking about. On the right, you can see a plan view of a horizontal well. That's the dark line that's going left to right. And then we have what we think are the ellipses of drainage for each frac stage on that well. There's models to model the frac behavior that are complicated to simple. We tend to stick towards a simple geometric model at this point while we're filling in to figure out what the more complicated, more appropriate frac model is for the complicated side. As you can tell, if we walk through the calculations, we go with our estimated ultimate recovery per well divided by what we think is our best approximation of the recovery factor. That provides us with a volume that we need to get out of the ground. From there, we can calculate the frac length that we think is happening and the actual drainage radius from that frac length in the rock itself. We like to do this by this method because we can overlap those wells, and you can see how much they overlap, which they tend not to. We try to keep the fracs not to, so we're draining all of the acreage that we are trying to drain efficiently and responsibly. So,
Great, thank you.
any questions on this slide? Okay.
Okay. And can you please walk us through Exhibit 16?
This is an exhibit of all of the wells in the area that we're looking at, and it goes through the calculation for every well to end up with, on the right, the drainage radius for each well. For everything in the Niobrara, we think it's 241 feet that we're draining on that shape from the previous slide. For the Codell wells, we think that it's 227 feet for the drainage of that ellipse. For reference, our wells are spaced at about 330 feet apart, and we think this is within the 460-foot standard setback for the DSU, based on what we know now.
Great, thank you. And can you please walk us through Exhibit 17?
Absolutely. All of the estimated ultimate recoveries from the previous slide were made with the ARP's decline curve analysis model. Our reservoir engineering group does this methodically for all of the different wells in the basin. So it's a standard practice, and we've applied that methodology to all of the wells on the previous slide. So we have pretty good confidence in how we're applying the decline curve analysis to the calculation of the drainage radius as much as we can now.
Great, thank you. Any questions?
Any questions from any of the commissioners? I'm sorry, I just can't let you get away.
I knew you were going to have a question.
So, I think as was brought up, there's a surface use agreement in place, correct?
Correct.
So, distance from your surface facilities to nearest residence or a building, can you give me an estimate of that? Please.
Greater than 500 feet from a home.
Greater than 500 feet
Yes.
from home. All right. Thank you very much.
Unless there's any other questions, I would request approval of docket number 1703-00116 and the requested relief set forth in the application.
So moved. Is there a second?
Second.
It's been moved and seconded. All in favor of the approval, please signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Thank you very much.
Great. Thank you very much for your time. Thank you, Mr. Rouse.
So, Mr. Gowan.
Next matter on the agenda is docket number 170500309, Bonanza Creek Energy Operating Company. And again, Jim Rouse is the hearing officer in this matter and may have some introductory comments.
Good morning again, commissioners. This is a application by Bonanza Creek Operating Company, LLC, requesting approval of certain applications for permits to drill, which were being held up by staff. Staff objected to the application, and my understanding is that sometime yesterday they managed to settle their differences. I have no idea what they agreed upon, but they will tell you about their settlement here.
Good morning, Commissioners. Kyle Davenport, Assistant Attorney General for the COGCC. Mr. Rouse is correct that staff and Bonanza Creek have come to an agreement. If I may, I would like to hand out copies of that agreement so that you've seen it, you see it. It is not yet signed, but it is the final version of the agreement. It's not yet fully executed. Pursuant to that agreement, the parties have an opportunity to present their side to you. Staff, I believe Director Lepore intends to speak to you briefly about why staff placed a hold on those applications. Bonanza Creek will have an opportunity to present, but I don't believe I don't believe Bonanza Creek intends to present. And at the conclusion of Director Lepore's presentation, Bonanza Creek will move for a dismissal with prejudice of their application. As you see in that agreement, one of the provisions is that staff does agree to issue the APDs and Form 2As with appropriate conditions of approval by a week from today. So I know that Director Lepore would like to speak to you about this briefly, but we don't seem to have him right now. If you have any questions for me in regard to the agreement, I'd be happy to answer them while we wait for Director Lepore.
Maybe Commissioner Randall may have something to say.
Sure. I mean, I'll just say Matt had to run to his office to grab something for this matter, so he'll be back in a moment.
Okay.
If there are questions, perhaps the commissioners could ask them at this time, and otherwise we can wait for just a second.
Is it possible to sort of briefly highlight?
Absolutely.
What the matter is before us?
And we do have Bonanza Creek and counsel for Bonanza Creek here as well, so I'll ask them to chime in if I misstate anything. This matter arose by an application of Bonanza Creek requesting that the commission approve APDs and Form 2As that were submitted for development in Weld County. The grounds of the application were that 75 days had passed since COGCC staff's completeness review, and pursuant to Rule 303, Bonanza Creek was entitled to make an application to the commission for approval of their APDs and Form 2As. This weekend, we reached an agreement whereby staff agreed that they would issue the APDs and Form 2As, and pursuant to the terms of the agreement, Bonanza Creek's agreement that it would not file applications to drill or Form 2As in the application lands for a period of 12 months. For that, Bonanza Creek has also, so the issue here, and I know Director Lepore will give you more detail here, but staff's preference after consultation with the surface owner is that these lands were developed on a 1280 acre spacing basis rather than a 640. But pursuant to the way that Bonanza Creek's leaseholds were, et cetera, Bonanza Creek was unable to, at this point in time, develop on a 1280 basis. There is the possibility that pursuant to agreements with other operators in the area that development could occur on a 1280 basis. And part of the purpose of this agreement is to allow for that to happen. That is the purpose of the 1280 acre applications that Bonanza Creek has filed and has agreed not to withdraw. It is also the purpose of staff intends to file a motion for our next meeting to reduce the spacing in one section down to, or to reduce, the well density in one section, which is spaced at a 640 acre basis, down to just one well. And the purpose of this agreement, in recognition of the surface owner's comments as well, is that to encourage or to allow development on a 1280 acre spacing basis. Do you have any questions following that?
I think, so what I heard is that there are some Form 2 and 2As that will be approved, but on a limited amount. And I think rather than continue to try to fill the dead space now that Director Lepore has returned, we'll let him speak. Is that all right?
That's generally correct. You can see in the agreement the second or third and fourth whereas clause call out the APDs and OGLAs at issue.
Okay, thank you. Director Lepore?
Thank you, Mr. Chairman. My apologies. Enrique, I do have a slide. If you could just bring it up, I don't have to. Oh, I might need a pointer. Just go to slide format. Great, thank you. Apologies again for stepping out, and I'm not quite sure what you've been told as baseline, but I became aware of Bonanza Creek's proposal, the applications for Form 2 and 2As, gosh, many months ago, maybe a year ago, maybe not quite. And was aware at the same time that the surface owner was concerned about development. And then became aware that every other section essentially is owned by Anadarko in the sort of checkerboard pattern. So the colors are a little bit hard to see on this slide. But for example, section 23 is Anadarko's, and to the east of that, 24 is Bonanza Creek's. And going to the west, then 22 is Bonanza Creek's, and 21 is Anadarko's. And that pattern plays out all the way through that township, going south out. Bonanza Creek is running up against lease terminations. If they don't drill a well, the primary term of their leases will expire, which is not a good outcome for them. But when I look at this, what I see is an excellent opportunity for development along a central spine. And in this case, there's a road that runs right up between sections 22 and 23, north-south road, between, dividing that map primarily in half. So using that as a central spine, place your locations along that spine and drill 2-mile laterals going both east and west, really, from my point of view, is the ideal development pattern. Minimize surface disturbance, minimize the number of wells that have to be drilled, use those 2-mile laterals, which you've heard on different hearings that, kind of are more efficient overall. So I engaged with Bonanza Creek and with Anadarko in conversations about this opportunity and this possibility. I also engaged with the surface owner. I know that the surface owner had been reluctant to give surface use agreements to Bonanza Creek. I wanted him to understand that it was very likely that development would occur on these lands, even if he didn't enter into an agreement by virtue of the ability to bond on, and that what I was proposing was a way to, again, minimize the impact to him. So that's where I'm coming from, and that's why I told Bonanza Creek I would not approve their pending applications for permits to drill without bringing it to the commission, so you could see what I was aiming at. So on the left-hand side, I put sort of dark boxes around the 1280s. Obviously, that implicates both Anadarko's and Bonanza Creek's minerals. They need to have some kind of an agreement. I am satisfied that Bonanza Creek and Anadarko are working towards that agreement. They have been engaged with one another. I know that. And I know that both operators support this concept of trying to develop it on the 1280. The hurdle here has been the pending lease terminations. And as I think it's fairly common knowledge, Bonanza Creek has been working through a bankruptcy process and has emerged. And that's going to make it easier for them to enter into business agreements with Anadarko. So I just wanted you to be able to see the map, understand what I'm aiming at. I think when the commission has these opportunities, it is well within the commission's jurisdiction to drive for this outcome. That spacing these lands is one of your core functions. And if that means driving hard bargains, pushing operators to reach agreements, that's fine. And if it means that you're going to go ahead and approve 1280s and let them work it out after the fact, that's fine too, from my perspective. So here, again, I know there have been a lot of extenuating circumstances. I really do appreciate Bonanza Creek has, I know, worked very, very hard on this. This is, there are a lot of months and a lot of meetings and a lot of planning and a lot of conversation that are represented here. But again, I wanted them to have to bring this in front of you. And I think I came in on the end of Kyle explaining that we have reached an agreement. What that agreement accomplishes from my point of view is limits Bonanza Creek to just putting one of these 1-mile laterals in the sections they control so that they can go ahead and hold their lease but continue to work with Anadarko towards that 1280 development. My worry is that if I approved one of those, all but one of these sections is approved for multiple wells in the 640. So if they build a location and then drill one well, it's going to be tempting for them to go ahead with that 1 mile development. That 1 mile development results in 4 times as many surface locations and twice as many wells being drilled. So I want to keep the pressure on them. I want to disincent them from doing that. And this agreement helps by they're agreeing not to drill any 1 mile laterals, any more 1 mile laterals for a year. And hopefully in that time, they can get something pulled together with Anadarko and try to do this on 1280s. So I think, and I'm not sure that this stipulation needs the commission's approval. I'm not sure how we got that procedurally set up.
I don't believe the stipulation needs the commission's approval, though I think we'd certainly like to know if anybody disapproves of something like this. But I think what needs to happen probably is for Bonanza Creek to move for dismissal with prejudice of their applications. And go ahead, Rob.
Just a moment. I think Commissioner Hawkins, I think you may have a question, and we may have some other questions before we move forward, if that's all right.
I just wanted some clarification, make sure I'm understanding. The current spacing is 640.
The Bonanza Creek lease controlled sections have been spaced on 640.
Okay, and there is no application yet for 1,280 acre spacing.
Actually, Bonanza Creek has filed applications to change the spacing to 1280, and part of the stipulation agreement is that they pursue those in good faith, that they not withdraw those, they keep them on the docket and pursue them in good faith.
Yeah, I guess the only other comment that I have is kind of to support your opinion that if the commission were to determine that 1,280 acre spacing was the most appropriate in this area, we could establish that spacing even without an application from Bonanza Creek.
I think that's correct, Commissioner. You can take action on your own motion or a motion of staff, and what we would have moved in that direction had we not gotten to this place. We would have done something. I would have asked in some way to limit the development of the 1 mile laterals and moved in this direction.
All right, thank you.
Mr. Jolly?
Is what you're saying that they're going to drill, do they have to drill 6 wells this year to save 6 sections? Or did I hear you say that the 1 well, there's an agreement to extend the lease if they drill 1 well?
My understanding, and this might be better for their counsel to answer, my understanding is that they need to put 1 well on each of the sections. So they've asked for 7 APDs to be approved. It is my understanding that they believe they need all of those to hold the lease because of pew clauses that limit what gets held to those sections on which a well has been drilled.
Another question, and you may not know the answer to this, but it appears that Hobe Minerals owns the mineral rights. Do they own the mineral rights on the Anadarko offset sections?
It's my understanding that Anadarko is the mineral owner of the offset sections.
How many locations get built to drill these 6 wells?
They think they have 6 applications for oil and gas locations, or 7. One location for each of the wells.
If they build these locations to drill 1 well, isn't that going to be tempting to continue from there? Isn't that defeating our purpose?
Very fair question, Commissioner, and exactly my concern is that I've expressed to them many times that once they go down this path, I think it does make the path of least resistance after that to continue where they are. they have, in our conversations, they could use those locations that get built along the road may be able to be converted. I think then hopefully they will build smaller locations for the ones that are not along the road, from which they just plan to drill one well at this time, so that if the deal is worked out and a new location is built along the road, they'll have just one small location. But so the insurance policy that we've asked for is that right now they won't drill any more wells on any of those locations for at least a year. And we'll know sort of before that, I think, whether they've been able to reach an agreement with Anadarko for the 1280 development. We'll know whether they proceed with the 1280 spacing, for example. And there are still some cards in our hand we can play if we get to that place.
Is it beyond our authority to try to deal with Brian O'Hara or Hobie Minerals in trying to come up with a grand solution to this? He's the one, seems like, is driving this with his pew clauses.
That is something I cannot speak to, Commissioner. I will tell you that as a general principle, we do not engage in sort of these private business negotiations. I think I've pushed my own powers relatively far in this case, which I am comfortable doing under certain circumstances. But going to the mineral owner and asking him or her or whomever it is to kind of grant an extension of time would be one way to get here, maybe. Alter those pew clauses, all of that, I think it's pretty touchy in terms of private contract.
Okay. I do support your efforts, sir.
Thank you.
So I think perhaps Mr. Willis might like to elaborate a bit on some of this material that came forward.
Thank you, Commissioner Benton. My name is Rob Willis. I'm an attorney at the Shaner Group Law Firm. I'm here on behalf of Bonanza Creek Energy Operating Company, Inc. In attempting to resolve this with staff, it was agreed by my client we wouldn't make a presentation today. That's part and parcel as to why, we're not going to try to give our side of the story, I suppose. However, Kurt Moore, who is the Senior Vice President of Land, is seated in this first row here, and he might be able to perhaps allay some of your concerns if you have questions towards him with regards to development. Acting in conjunction with the stipulation that was reached between the parties over the weekend, Bonanza Creek Energy would be withdrawing their application for APD OGLA hearing today. So that was really the reason why I was going to come up and at least make some kind of a presentation or some kind of showing today. If you have any questions, certainly Mr. Moore can take those.
Sure, I would appreciate hearing from him.
I think from what I can see on the plat that was put up, that at least 3 of the 6 locations can potentially be used for 1280 development because they do lie along the road. Is that correct?
Yeah, Kurt Moore, Bonanza Creek. If you're looking at the plat, the blue circles with purple diamonds around them would be surface locations. So yes, there would be 3 locations that would work both for our intended 1-mile laterals to hold leases that could also be converted in the future to go 2 miles in the event we can reach a private contract with the offset mineral owner.
So I think, I'm not sure if there's another question. I think what I was left with is that you were sort of concerned about what's going on with the mineral owner. Maybe all.
Well, I just was.
Sorry. Go ahead.
This may be obvious, but it just seems like the mineral owner might be the obvious solution to this issue. But I'm assuming you probably tried to deal with him, but if it could, a bargain could be made with him, assured him he'd get drilled. If by cooperating with Anadarko there in a bigger picture, it'd make me more comfortable.
Let me just give you a little bit of a history. Bonanza Creek purchased these leases from another operator.
Microphone, please.
Bonanza Creek purchased these leases from another operator in July of 2014. And they are already in a primary term, and we extended them an additional 30 months. And those 30 months are going to expire in November of 2017. So we will continue to work closely with the mineral owner, and we will certainly engage the mineral owner as part of a 1280 development plan. We're comfortable that the Hobie group is just interested in getting their minerals developed. And but I'm not comfortable that I can do any more extending or additional maneuvering in the leasehold to hold that. So we had to make a conscious decision to apply for these permits and get our leases held by production. Director Lepore is correct. Bonanza Creek has been spending the better part of a year in a financial restructuring that disables private contracts about as good as anything. So we believe now that we've emerged, that was effective last week, Friday. So we're a new Bonanza Creek as of today. We believe we can go forward with more energy to bring forward the 1280 development plan in one way, shape, or form of another. But the urgency of holding these leases is very paramount to our enterprise value here. So that's why we've applied for the permits that we've applied for. Certainly, we could drill the first 3 along the main road, and if we could convert at any time to the 1280, we would work collaboratively with the staff and the director to make a conversion. We've evidenced that many times to the staff that if later this week or 30 days from now, if we could get to the 1280 solution, we will immediately start unplugging 1 mile laterals and start plugging in 2 mile laterals. But the purpose of our applying for this hearing and the purpose of the conversations with staff and the director is just to give us some assurance that if those private contracts don't come forward, we've got a path to save our leases.
Okay, thank you.
So notionally, if you get that before your leases expire, you could proceed ahead with 1280 development on the whole block.
It's certainly not out of the question. It's just a very complicated lease. It's not a 2-page lease. It's a multi-page lease. That very complicated horizontal and vertical pew clauses, and we just need to make sure we're hitting all those dates right, and we will.
Best of luck to you.
Yeah, that's what we do.
Yes. Sorry, Commissioner Ager.
Sure. Director, has the surface owner seen this agreement, and is he aware of the agreement?
Thank you, Commissioner. Yes, I spoke with the surface owner yesterday evening, like 6 o'clock, to let him know that we were in this posture, and I think he remains appreciative of the planning and coordination. So he was fine. He had intended to come and make a 510 statement. You'll recall that he did so up in Loveland. And we had invited him to come back and do so here again. But with this in place, I explained to him, I hope clearly sort of what we've talked about today, that we still hope and want the 1280 to happen. But in order to make sure that the leases don't expire, we've got this kind of a compromise solution. He was fine with that.
Great, thank you.
I think
The hearing's vacated.
is that your request? Okay. I think, do we need a motion on that? Help me out.
My understanding is you're just withdrawing your application. There's no more application to have a hearing on the APDs. We will approve the APDs and Form 2As by May 8th was the agreement. I think we're good.
So no further action needs to be taken on this. Thank you.
Thank you. Thank you.
Okay, Mr. Gowan.
Next matter is docket numbers 170500189, and then sequentially the same numbers with 190, 191, 192. This is Crestone Peak Resources Operating. And this is one of the matters that was resolved over the weekend, and I believe that Director Lepore will kind of explain what you're going to be listening to.
Thank you, Mr. Gowan. So, Commissioners, this relates to Crestone Peak's application for a comprehensive drilling plan, and scheduled for hearing had been their request for what they termed a variance, pursuant to which other operators would be precluded from filing Form 2s and Form 2As within the application lands for the CDP. The other operators have protested your granting of that relief. Over the weekend, the operators came to a private agreement that they have now put in front of you in the formulation of a stipulation for voluntary standstill. And the first thing I need to know is whether you have gotten a copy of that voluntary standstill in your hands, because it all happened pretty quickly yesterday evening, and I'm thinking it's possible that you don't have a copy of it.
That is correct.
So we're going to have somebody go make a bunch of copies while I talk, because you are going to be asked to vote on, you're going to be asked to enter that stipulation as a commission order. So what I would like to do first is just talk about the comprehensive drilling plan and the application in front of you and the process sort of going forward from here, assuming you're okay with the stipulation that they have presented to you. So what I did pass around are excerpts, or actually the entirety of Rule 216, COGCC Rule 216, you have in hard copy. And then the document that's on the landscape printing is a modified version of those rules that includes additions by staff of certain requirements that we would like Crestone Peak to come forward with in the way of information and planning as this process goes forward. Before I get too far, I also want to call attention to the fact that the application lands are in Boulder County. The application lands essentially consist of 3 side-by-side 2,560 acre spacing units. Those are stand-up spacing units. They're oriented north-south, and they lie side-by-side in an east-west direction. So it's a total of approximately 7,500 acres, 12 square miles, that Crestone Peak has proposed to do the comprehensive drilling plan. And the benefits of the comprehensive drilling plan are working with stakeholders, including and perhaps chiefly, in this case, the county, Boulder County. The comprehensive drilling plan, if you look at 216, contemplates coordinating with Colorado Department of Public Health, Welfare and Environment. Actually, welfare is not in there. There's enough letters without it. CDPHE, Colorado Parks and Wildlife, with the county, and with other stakeholders. Boulder County is present, their representatives are present, and they did file a 510 statement in support of the comprehensive drilling plan. So I just wanted to call attention to that and make sure you have seen that. That should be in your docket. Like the matter we just heard, where we were pushing for 1,280 acre development. You guys want to comment? Yeah, when I'm done, you can comment. Okay. I'm not going to be done for a while, but if you're comfortable there, that's fine. Like the 1280 development, we support this concept of developing, in this case, 12 square miles in a thoughtful, deliberative, comprehensive way. You can probably infer from the protests that Crestone Peak doesn't have all the acreage. The other significant acreage mineral interest holders are Extraction, Oil and Gas, and Anadarko. So those 3 operators control about 95% of the minerals within that 7,500 acres. Crestone Peak is offering to come up with that comprehensive plan, which means, again, minimizing the surface locations, thinking about infrastructure in a comprehensive way so that you don't have 3 separate operators developing their own infrastructure systems, 3 separate operators building their own locations, 3 separate operators potentially drilling and stimulating wells all at the same time. So we see lots of advantages to proceeding with this plan under 216. The rule 216 was put in 2008, has been only used once. So we're pleased to see an operator try to take advantage of the rule. And I think what has driven us to this point of Crestone asking for a timeout from other operators filing applications is to give them the time it takes to think through where will locations go, where will infrastructure go, things like that. And certainly as well to reach agreements with the other operators who have significant mineral interests as to how they want to divvy up operations or trade lands or do other agreements privately between them so that they all benefit from the drilling plan and have an opportunity to develop their minerals. Thanks. So I just want you to understand that bigger framework, that larger context. Today, the only relief that was to be requested was the standstill agreement so that there would be time for Crestone Peak to develop the plan. The stipulation that the operators have entered into results in a standstill. It's merely a private voluntary agreement that none of those three operators will file Form 2s, that Crestone will file 2As with its plan and not otherwise. The final plan will come in front of you for your final approval or not under the current plan schedule on February 1st. So the standstill agreement is for a term of 9 months from today. And that's, I think, a reasonable time. I think it will keep Crestone busy for the next 9 months as they try to identify surface locations, work with all of the stakeholders, continue to work with staff, et cetera. With that, I'll just, if I could, direct your attention to the document that's on the landscape. If you look at that, what that is a expanded version of Rule 216. If you turn to the second page, you'll see lots of red text. And then we've got the 3 columns for conceptual, preliminary, and final. So staff went through 216 and said, okay, there's some additional detail here that we need. And that's what the red text is. And then we said, maybe we don't need that right now to kind of get to this standstill place, but as this plan progresses, we are going to want to see more detail in stages. So that's the plan in place. Crestone has seen this document and is comfortable with this document. They've provided us all of the material that is marked conceptual. Based on that material, the staff is comfortable. We would have been comfortable with the standstill. That's what we would have recommended to you. And then going forward, we'll get the preliminary and ultimately the final. From here, we need to set out a time schedule for Crestone. So for example, when is the set of information that's marked preliminary due? When will certain stakeholder meetings take place, et cetera? We will do that with Crestone in the near future. And I think that's really all I kind of wanted you to understand, the groundwork, the framework here. Executive Director Randall handed me a note that says Boulder supports the variance request, but not the CDP. So that's probably why they're sitting there eagerly waiting to say that. I'll let them say it for themselves if they'd like, but that is true. I misspoke. They supported the standstill agreement. I think they're in general agreement with comprehensive planning, but we'll let them speak for themselves. And I'm happy to answer any questions.
Any questions from any of the commissioners at this time? I have only one. Is this a document, because there are 2 other, as you said, there are 2 other working interest owners in this area. And is this a document that gets shared with them also as you go along?
Yes.
Okay, thank you. All right, I think now we turn it over to Boulder to speak.
Thank you, Commissioners. Kate Burke, Boulder County Attorney's Office. And yes, the director and the executive director are correct. We wanted to clarify our Rule 510 statement, which hopefully you have and might get a chance to look at, specifically supported the variance request. And I think I can go so far as to say in general, Boulder County is interested in the most comprehensive and efficient and coordinated planning possible. But we're basically reserving our thoughts and opinions on the CDP overall as it develops.
Good morning, Commissioners. Kim Sanchez, Chief Planner with the Boulder County Land Use Department. If I can offer just a couple additional thoughts as well. So first off, good to see you again. And you may be surprised to hear that we're actually in favor of something like the standstill. So hopefully that is a good surprise for you this morning. I think we also are supportive of the CDP effort in general terms. I think that we were pleased with the outcome that occurred from efforts made over the weekend in all parties agreeing to the standstill today. We think this is a real opportunity to do something that the governor's task force rulemaking was perhaps not able to do, and that is to work collaboratively with local governments, particularly our county, as we move forward. So if oil and gas development is to occur in Boulder County, and as you know, our moratorium expires today, the CDP allows for this to occur in a way that we think could reduce impacts to our residents if their input is heard, as well as Boulder County's input. So a couple of comments that I just would like to leave you with are related to process moving forward. So Director Lepore outlined that they need to set a time schedule, but I'd ask you to have a keen eye on what gets set moving forward. So while there are benefits to having a voluntary standstill, we do have concerns about how the process will proceed in a productive and transparent manner, which involves having a very clear process, not only to the stakeholders, and I don't know that Boulder County has had a very clear sense of how things will proceed to date, but more to our constituents, to our residents and people that are going to be involved with providing input. So we've been inundated with questions about how this process will work. This is something new, and something new particularly in this context of front range planning. So what will this process look like? We've been participating, as I said, and don't really have a clear idea ourselves. When will there be opportunities for input, particularly in front of the commission? And so February 1st was the date that we heard. We'd like to, let the public know if they'll be allowed opportunities to speak before that or only at that time, and how that will be done. What criteria will be used to approve a comprehensive development plan? By what standards will you, as commissioners, find that CDP to be acceptable, supportable, or approvable? Those are all things that have not been clarified to date that we're asking for some direction on. So we do think this is a good opportunity, but in order to make the most of it, we encourage you to look at the process, really think it through, make the documents accessible to the public. It's very difficult to try to find any of the materials related to the CDP on COGCC's website. So some help in that area would be appreciated. And we just ask overall for the allowance for clarity, predictability, and transparency so that the people involved know their opportunities to participate. Thanks for your time.
Would you like to have something to say?
Not if you want to say something first.
No, I do, but I want to hear what you have to say.
I think that this, so Rule 216 is pretty thin on procedures, and so to a certain extent, we have been making it up on the fly. That said, Crestone has coordinated, organized 2 meetings for stakeholders, and Boulder County has participated in both of those. The schedule that got us to this point was shared with all of the stakeholders, and we'll continue to do that going forward. We have not gotten materials on the website, and I apologize for that. Just the press of other business, I guess, is the best I can offer. But we will, and I think stakeholders such as the county certainly have the right to protest the comprehensive drilling plan that does come forward if that's where they end up on it. So there are those procedural mechanisms remain in place. But I think Crestone has made a very legitimate effort to be transparent, to engage with stakeholders, to organize these meetings. And again, Boulder has participated in those.
Thank you. So I heard 2 things out of that. One is the Commission's efforts to publicize this and provide ease of access, which I think is important, is how quickly can you get to this and see what's unfolding as this progresses. So I heard that. Appreciate that. I think, and secondly, I think there was a question that you asked about sort of when does the public get involved and how does that process work? So I think more clarification around stakeholder meetings and how public they are, I think is going to be important as well. Because I think Commissioner Hager mentioned earlier, it seemed like that some of the surface owners that are directly impacted by this have expressed some concerns about the process and getting involved in it. So I think I think I heard that we're undertaking to do that. I just wanted to make sure that that's what I heard.
I think that is true. I believe, and they can clarify if I misstate, but Crestone notified all of the surface owners in the 12 square miles that they could identify. It was a very long list. I think as this gets narrowed down to actual locations, then in terms of who are potentially parties under our rules, that list will narrow.
Good thing I ducked.
Trying to wake me up.
Yes. I think the last comment is just to applaud Crestone. This is a significant undertaking. I think that the opportunity to sort of create this and bring more comprehensive development plans forward, I think is going to be a significant benefit to further development in areas here along the Front Range.
Thank you, Commissioner. And I guess to indicate my support for that, will tell you that I have previously spoken to Crestone and Extraction, both who had engaged me with the fact that they had significant mineral interests in Boulder County, looking to develop those. And, so this is something that we have definitely pushed. I do want to clarify, just so it's very clear, that's why you clarify, right? The standstill agreement is a joint effort by all three parties. They've all three executed it, just so you know. This wasn't, it is a collaborative agreement. I think that's all.
The stipulation for voluntary standstill has been couched as a order of the commission, so it would be appropriate to entertain a motion to approve it. I do want to note for the record that what was handed out today is what was sent to us late yesterday. This morning we have made minor formatting changes to put order numbers and a cause number on it. So the parties that sign the stipulation, we will ask them to sign the copy that you approve. But it would be appropriate to for a motion to approve the stipulation for voluntary standstill.
So other than minor wording, this is essentially the document we would be.
Right. The only thing we've done is we've added order numbers so that we can properly index this order with our database.
Okay. Any further questions, concerns? Yes, sir.
Comment. I just want to express my appreciation for Crestone to move forward with a comprehensive development plan. I know it's been almost 10 years, 9 years since that rule was put in place. This is what I understand is the first one to come forward. So I'm excited to see that precedent set and hope for a favorable outcome from all parties' point of view. So I'm happy to see that come forward.
Would you like to turn that into a motion?
I would definitely do that. I make a motion that we approve the stipulation for voluntary standstill. Do I need to add more to that?
I think that would be sufficient.
All right.
Second.
Moved and seconded. Any discussion? Glad that was read into the minutes. Okay, all in favor?
Aye.
Aye.
Opposed, same sign. Motion carries. The stipulation is passed. Okay. Mr. Gowan, what's next on our list?
We have one more docket item. It's a combination of two docket numbers. They are 1703-00131 and then 1703-00132. This was originally set for a contested hearing. Just this morning, I've heard from council that they have a deal, and I think I'll leave it to Hearing Officer Jim Rouse to at least set the table for this.
Good morning again, Commissioners. Jim Rouse. I'm the hearing officer on 1703-00131 and 1703-00132. These are two separate pooling applications that we have combined for hearing, but there will need to be separate orders entered in each one. Both were protested by Extraction Oil and Gas, and it is my understanding that this morning they have reached a settlement and will be ready to explain that to you. Conoco will need to present a prima facie case to this because there was insufficient time to get it onto the consent agenda. With that, I'll turn it over to council.
I think from that
Counselor.
standpoint, we would just like to put on the record, this is Jamie Jost from Jost Energy Law. I'm speaking right into it. Can you guys hear me okay? Okay.
Yes, ma'am.
And Kelsey Wazelinski representing ConocoPhillips Company. We do have our witness here to present the what I'm just going to call the Rule 530 requirements for purposes of the pooling application, since it will now be unprotested. Both parties, and I'll let Mr. Pirishallo speak here in just a second, we have filed the formal notice of withdrawals with the commission themselves. The hard copy and the e-filing has also occurred.
Good morning, Joe Pirishallo with Wellborn Sullivan Tooley on behalf of Extraction Oil and Gas. Just confirm what Ms. Jost had to say is that yes, a settlement has been reached and a withdrawal of Extraction's protests in docket 1703-00131 and 132 have been submitted this morning.
Kelsey Wazelinski on behalf of Conoco. I'm happy to walk through both pooling applications. And we do have our land witnesses here if there are any questions about the Rule 511 land testimony that has been submitted. So these are two pooling applications submitted by ConocoPhillips. Docket number 1703-00131 is to pool all interests in sections 4 and 5, an established 1,280 acre unit in Township 4 South, 64 West, Arapahoe County, Colorado, and to subject any non-consenting interest to the cost recovery provisions of 3460-116.7, effective as of the earlier of the date of the application or the date that any costs specified in the Oil and Gas Act are first incurred for the drilling of the B&D land 464 4-5 number 4BH well. That's docket 131. Docket 1703-00132 is a similar pooling application request to pool all lands in a 1,280 acre unit established for sections 29 and 30, Township 4 South, Range 65 West, 6 p.m., also Arapahoe County, Colorado, and to subject any non-consenting interest to the cost recovery provisions for the drilling of the Rush 4-65 2933 AH well. And we do have our 511 testimony up, which is comprised of 4 exhibits. Exhibit number 1, this is docket ending in 131. This is the B&D well. We do have Jace McKenzie here today if you do have any questions, but we do have the well location plat as Exhibit 1. We have our notice list as Exhibit 2. We have our election letter, which was sent greater than 35 days before the hearing, and we have our AFE for each well. So I'm happy to have Jace come up for this one. We have Jake Stevenson, who's the landman for docket ending in 132, or I'm happy to answer questions on their behalf.
Any questions, Commissioner?
I think this is the right time to ask this. I don't know, right? As I understood it, the two issues were that Extraction thought that the drilling costs were way too high. And the second issue was that they thought that, the lateral should be 2,000 feet longer. I suppose it's not under our purview to know what you settled with extraction as far as the drilling cost part of it, but as far as our charge to make sure that the resources are fully developed economically, it seemed like they had a good point there about drilling another 2,000 feet. Was that part resolved?
It was resolved, yes.
Or I shouldn't say resolved. Was it agreed to drill?
Can you repeat the last question?
Did you agree to drill the other 2,000 feet to adequately?
Yeah, subject to confidential settlement agreement. And I will say that Conoco does have 2 approved APDs to drill 2 2-mile laterals in each unit as well.
So that does include that 2,000 feet that they were
The
protesting?
2 additional wells do include our 2-mile lateral wells. Yes.
In both cases?
Correct.
Yes. Yep. Okay, thank you.
Anything else? Any other questions, comments? I think, again, and you'll have to forgive me for not knowing the exact procedure, that if you're going to withdraw this, then there is no action needs to be taken by the commission. Is that correct?
No, actually, the protest was withdrawn. So each of these docket numbers need a separate motion for approval.
For the pooling. Thank you for the clarification. So we'll entertain a motion on the first one, I believe, is docket number 170300131. This is for 1280 spacing unit.
Mr. Chairman.
Yes, sorry.
Oh, I just thought there might be more for us to hear on this before we make the motion, but is this pretty much it?
We would request approval on both of these.
It's fairly straightforward, unless you have concerns. I didn't mean to jump the
The
gun
only
on
other
you.
concern, I mean, we know that there's extraction and ConocoPhillips. There apparently is a number of other parties that are not leased, maybe. Is that correct, or am I wrong in that?
I can't quite speak to whether all parties are leased in the unit, but I believe, and there are no other unresolved protests in this matter. So, yeah.
Okay. Thank you. I think there was a motion. So is there a second?
I'll second.
Thank you. Moved and seconded. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. The next one is a motion for docket number 170300132, also a 1280 drilling and spacing unit. So, entertain a motion.
It'd be a pooling application.
Pooling application, I apologize.
I'll move.
Second.
Motion, moved and seconded. All in favor?
Aye.
Opposed, same sign. Again, the motion carries.
Thank you.
Thank you very much for your time.
So
John, what's next?
that concludes all of the docket items that you have on your agenda today. However, you are scheduled for an executive session during your lunch break, and I will let Mr. Matter explain that process.
So under the open meetings laws, we typically do, you are entitled to enter an executive session to receive legal advice from me representing the commission on pending or threatened legal disputes. There are 3 identified on the written agenda, one of which was became unnecessary by virtue of the stipulation you just recently approved concerning Crestone. The other 2 are Martinez versus COGCC. The Court of Appeals number in that case is 2017 COA 37, and the purpose would be to receive legal advice and analysis of the Court of Appeals March 23rd, 2017 decision, and whether to pursue a petition to the Colorado Supreme Court to effectively appeal the Court of Appeals decision. And the other is Weld, Aaron, Water et al. Versus the Oil and Gas Commission, which is a relatively new piece of litigation in the Denver District Court, which is identified by 2017 CV 31315. And the purpose would be to receive legal advice and analysis of the complaint that was filed on April 12th and the amended complaint, which was received on April 25th. The Open Meetings Act enables you to enter into executive session, and the specific statutory site is 24-6-4023A Roman 2. And with that, Commissioner Benton, Chairman Benton, I invite you to, I encourage you to invite a motion to enter into executive session.
Consider the invitation sent out.
So moved.
Second. Okay, moved and seconded. All in favor, say aye.
Aye.
Aye. Here, so move into executive session. Thank you.
This is Jake Matter, sitting with the commission. It's May 1st, 2017. We are reconvening in open session after a brief executive session concerning the Martinez versus COGCC 2017 Court of Appeals 37 to receive legal advice and analysis of the March 23rd, 2017 Court of Appeals decision, and also the Weld, Air, and Water et al. Versus COGCC matter caption 2017 CV 31315 pending in the Denver District Court. And the purpose was to receive legal advice and analysis of the complaints received on April 12th and April 25th. We did so pursuant to the Open Meetings Law 24, CRS 24-6402-3A2. Chair Benton, it would be appropriate at this time for you to invite a motion to exit executive session. And I also wanted to note that no decisions were made. Now that we're back in open session, Commissioner Benton, I think it would be appropriate for you to invite a motion to exit executive session.
We'll invite that motion.
So moved. Second.
All in favor?
Aye.
Okay, so I think I ask you just briefly to say what we did.
Sure.
And the fact that no decisions were made.
Yes,
during that period of time.
Happy to repeat that. Pursuant to the Open Meetings Law, CRS 24-6402-3A, we were in executive session to discuss two of the three items identified on the hearing agenda today. Number one is the Martinez versus COGCC case, 2017 Court of Appeals 37, and Weld, Air, and Water versus COGCC, which is in the Denver District Court, 2017 CV 31315. And in both cases, we discussed legal advice and analysis of the opinion in the Martinez case and the complaints in the Weld, Air, and Water case. No decisions were made. At this time, I would appreciate receiving some guidance on whether the commission intends to seek review by the Colorado Supreme Court by filing a cert petition to review the March 23rd, 2017 opinion.
Thank you, Counselor. So it's my understanding from that as a group we need to discuss direction we'll take on whether or not to request to file an appeal to the Colorado Supreme Court.
That's correct. It's
Martinez.
sort of a two-step process. Number one, you need to file the cert petition, and if that's granted, then you would have subsequent briefing on the merits.
Thank you for that.
That's correct. So I need permission to pursue step number one.
Okay. So I'm going to invite commissioner comments.
Well, it appears to me that since we have a kind of a split decision at the appeals court, that it would be in our best interest to get some clarity from the Supreme Court on how they interpret that part of our statute. So I'm inclined to make a motion that we file for a review at the Supreme Court, or file the
cert petition.
Cert petition.
Okay.
That was a motion, right?
Well, I think it was, you said you were inclined, so I didn't see it as a
I'm just
motion.
saying, I thought we had discussion, or is this a motion we can make? I would be prepared to make that a motion.
I think I'll take that under advisement, but perhaps we might have a bit more. Commissioners may want to make some comments as well.
Right.
Yeah, I agree with Commissioner Hawkins, particularly when we see with the public comments that were presented today. I think that we and the public perhaps need a little more guidance on what that decision means.
Well said. So I'll just say I agree with both of those comments. I do think that it's important to note that an appeal here is to get clarity and guidance from the Colorado Supreme Court in light of a strong dissent at the Court of Appeals, as well as the historic practice of this commission. I think we need to note that this doesn't reflect at all an indifference to protection of public health, safety, and welfare. Everything the commission does in its rules and its consideration of adjudicatory matters and other things before it is really designed to ensure protection of public health, safety, and welfare are protected. It also doesn't reflect a sentiment that some level of degradation of those values is acceptable. Protection of health, safety, welfare, and the environment, including wildlife, are paramount in the Commission's rules and actions in everything that I've been involved with in my time here. So again, I think it's important to get clarity and guidance from the Supreme Court here on a matter that really just involves statutory interpretation.
Thank you. I think that well put. So at this point, no further discussion. We'll entertain a motion.
I would like to make a motion that we have the Attorney General's office file a cert petition for this case.
To appeal to the
Supreme Court.
Colorado Supreme Court. Okay.
Second.
Motion made and second. Any discussion? Being no discussion, we'll call the question. All in favor signify by saying aye.
Aye.
Aye. All opposed, same sign. Motion carries. I believe that may conclude our business today, but I better check with Mr. Gowan to make sure.
You believe correct. There is no additional business on our agenda.
Then
Motion to adjourn.
Second.
Okay. Hearing no opposition, we're adjourned. Thank you all for the time. Thanks to the staff again. And I can't say enough about all the effort that was put together this weekend to help resolve a number of issues that were in front of us for this particular hearing. So thanks again to those that are no longer here in attendance.